This is Barry Zalma on insurance. I'm an attorney who's retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today, we'd like to speak about some defenses to intentional torts, because every tort also has a defense, and every insurance claims person, every insurance claims lawyer or defense lawyer needs to be familiar with these defenses. One of the first would be self-defense or defense of a third party. For example, the California Civil Code states, quote, "Any necessary force may be used to protect from wrongful injury the person or property of oneself or of a wife, husband, child, parent, or other relative, or member of one's family, or of a ward, servant, master, or guest." This is California Civil Code Section 50. The person must reasonably believe that danger exists and must use only such force as is reasonably necessary. A New York appellate court explained that the following jury instruction on self-defense was appropriate. Quote, "Defendant claims he was acting in self-defense and therefore is not liable for damages to the plaintiff. The defendant has the burden of establishing self-defense by a fair preponderance of the credible evidence, as I have already defined that term for you. In order to establish self-defense, the defendant must establish that he reasonably believed the plaintiff was attacking or about to attack him, and that the force that the defendant used to prevent injury to himself was reasonable under the circumstances. In order for the defendant to be justified in using physical force, you must find the following factors. First, whether the defendant was the initial aggressor. Initial aggressor means the person who first attacks or threatens to attack. The actual striking of the first blow or inflicting the first wound is not itself determinative of the question of who was the initial aggressor. A person who reasonably believes that another person is about to use physical force upon him need not wait until he is struck or wounded. He may in such circumstances use physical force defensively, so long as it was reasonable for him to believe that the other person was using or about to use physical force upon him. He is then not considered to be the initial aggressor, even though he strikes the first blow or inflicts the first wound. Verbal quarrels, the use of abusive language, the calling of names, or verbal threats do not justify the use of any physical force. You may not consider any of these in determining who was the initial aggressor. If you are satisfied that the defendant was the initial aggressor, then you must find he was not acting in self-defense. This is a case called Killen v. Parata, a 2016 decision of New York's appellate courts. Now, we talked about the tort of battery. A defense to the tort of battery is the use of deadly force. Deadly force, or force likely to cause bodily harm, is not justified merely in defense of property. Spring guns or other deadly mechanical devices are to be used only if deadly force is justifiable. deadly force may be used against a felonious trespasser. Reasonable force is always a defense. For example, holding a violent person's arms behind his back, striking a dog about to attack a child, holding a person who was intentionally striking a child, or escorting a trespasser off the premises. Defamation, including libel and slander, can be defended with an establishment of evidence that are not limited just to the truth, which of course is a complete defense to a defamation. Reasonable but erroneous belief in the truth of the accusation, however, is no defense. The erroneous belief merely changes the tort from intentional to negligent defamation. False imprisonment can be defended by establishing reasonable detention without arrest, which is a judicial privilege codified by the California Penal Code at Section 490.5, paren F, close paren 1, close paren. For example, a storekeeper who believes a theft has been committed may detain the suspected person for a reasonable time. Other types of detention found to be reasonable include detention by a librarian, search by a merchant, detention of a patient, or arrest by a private person when the person arrested has committed a felony. Champerty and maintenance are also intentional torts and can be defended by asserting that using venture capital to finance litigation has been tolerated in many states because defendants often have more funds available than the injured plaintiff. Recently, the Ohio Supreme Court and a few others have called into question whether such arrangements violate the traditional rules against champerty and maintenance. Champerty is a form of maintenance in which a non-party undertakes to further another's interest in a suit in exchange for receiving part of the proceeds in the event of a favorable recovery. The purpose of champerty is to preclude third parties from investing in litigation. In this regard, champerty is a subset of the broader doctrine of maintenance, which states that only individuals who have a bona fide interest in a case are entitled to assist the litigant in pursuing or defending a suit. Courts consider maintenance to be an officious intermeddling in a suit, which in no way belongs to one by maintaining or assisting either party with money or otherwise to prosecute or defend it, while champerty is a form of maintenance whereby a stranger makes a bargain with a plaintiff or defendant to divide the land or other matters sued for between them if they prevail at law, whereupon the champertor is to carry on the party's suit at his own expense. Malicious prosecution can also be defended. A termination of a case consistent with guilt or with civil liability is not a basis for the tort of malicious prosecution. The plaintiff must show that the original action was brought without a lack of probable cause to make the criminal charge or to file the civil suit. If the defendant honestly and reasonably believed in the truth of the charge, the element requiring a favorable termination of the original case fails. The defense must be independently proved. It cannot be inferred from proof of malice. Advice of counsel is also a defense establishing probable cause. The existence of probable cause is a complete defense to a claim of malicious prosecution. In the 1980s and 1990s, when I served as coverage counsel to insurers, the people who filed bad faith cases against insurers who denied claims did not like bringing suit in federal court or being dragged into federal court because for some reason it was more difficult to prove a bad faith case in federal court. To avoid federal court, they taught that it was appropriate not only to sue the insurer for bad faith, but to sue the insurer's adjuster and lawyer. And by adding additional defendants, they were able to avoid the federal jurisdiction. I was personally the victim of dozens of such frivolous lawsuits, claiming that I individually sold an insurance policy to an insured and promised to pay all of his claims, even though I never acted as an insurance company or an insurance agent or broker. My only involvement, therefore, was as counsel to the insurer. And so when I was sued, I would move for summary judgment with a sworn declaration that stated I am not now, nor have I ever been, an insurance company or an insurance agent or broker. Those motions for summary judgment were eventually awarded, and the cases against me were dismissed. Now, because I was put in a position of losing a great deal of money defending myself to these frivolous lawsuits that were designed solely to avoid federal jurisdiction, I instructed my counsel to sue the lawyers who sued me for malicious prosecution. And because I was able to prove that the case was terminated favorably in my favor, I was able to maintain a malicious prosecution action against those lawyers and their clients. And this eventually stopped the frivolous lawsuits to avoid federal jurisdiction, because I had a good case and would eventually win those cases or settle them, which mostly they settled for as enough money to make up for my lost funds in paying deductibles and paying counsel. Malicious prosecution is a terrible abuse of the rights of a party defendant and a terrible abuse of the duties and obligations of a lawyer, who must bring a lawsuit only when he or she has collected sufficient facts to establish a probable cause for bringing a suit against the individual. This video was adapted from my book, Selma on Insurance Claims, Part 105, Second Edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be useful or of interest to you or your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel, my Rumble channel, my blog, Substack.com, where I post videos and blog postings. Thank you for your attention. And please, if you have any comments, please send them to me at zalma@zalma.com.